Hi, good. Thanks for joining me today. I have a really special guest. It's going to be a fantastic podcast. I have with me privacy practitioner Sandra Ezri joining us from Switzerland today. And this is going to be a fantastic podcast because, I've been talking about GDPR as it relates to FATCA, and there's some lawsuits going on. But, GDPR is really affecting my clients around the world and globally, and it even affects me, too, as so many of my clients that we get come from the EU, and we specifically target people in the EU for their U.S. tax for their U.S. tax returns and help. So GDPR applies for me, and I was mentioning to a friend of mine. The issue. I said, hey, she's general counsel of a small publicly traded company, Sandra, and I asked her about GDPR. I said, hey, do you ever have? I asked her this question. I said, do you ever have any GDPR headaches? And her reaction, I can't really repeat her reaction. Google would probably ding us a little bit if I actually quoted her exact words, but generally not a fan of GDPR, and it's full of a lot of headaches. So joining me today, again, I am Anthony Parent of IRS Medic, the Bowen Partners, and joining me today to discuss this topic is Sandra Ezri of the Bowen Partners. Sandra, thank you so much for joining me today. I really appreciate it.
Thank you, Anthony.
All right, so we created a presentation, basically how to make GDPR less terrible for your business, and really this is sort of targeted for U.S. businesses doing business in the EU, but also anyone in the EU could benefit from this as well, right? There's no reason why not, right?
That's exactly right. Yes.
All right, great. So we're going to pull up our presentation. We've been working hard on it together, and it's going to be a lot of fun. So we're going to go through. Let's start with our first slide here. Sandra, and let me get up. Oh, by the way, Sandra, I should ask you a few questions. So where are you located?
I am located in the UK,
okay.
But I work closely with the office in Lausanne, Devo and Partners.
All right.
So,
right.
yeah.
And now you are a privacy practitioner. Can you just explain exactly what that is?
Yes. So I am a certified CIPPE. Which allows me to work under GDPR, advise under GDPR, mainly European GDPR, but that also covers UK GDPR, which has not yet diverged so much from the EU GDPR. And I'm also very knowledgeable under Swiss data protection law. There was a new law entering into effect last year in September, actually. We're coming to the first year anniversary. And so I can also advise Swiss clients under GDPR or clients abroad wanting to do business in Switzerland.
Oh, wonderful. Okay. So we have some bullet points here. So who does the GDPR apply to? Let's just answer that one first.
Yes, I think we will go into the details of each bullet point in our slides, but yeah, that's a very good question. You were talking about your colleague, friend nightmare, and
yes.
It's true. When you're not familiar with GDPR and you start looking into it, it can be very overwhelming. But we have solutions to make it a little bit more user-friendly and easier to tackle. So
yeah.
we will look at who does the GDPR apply to? Does it apply only to European firms or does it apply to firms abroad as well? We will see what an inextricable link is, because that's a very important term for firms that are dealing outside of Europe and think that they're not under the scope of GDPR. We can look at what small business companies have encountered as problems. The type of
and I just want to explain here, the reason why is because a lot of the large firms, they have the resources to tackle it. It's the smaller firms that don't have the back, the support. So that's where we're really focusing on the issues of the smaller medium businesses that don't have their own in-house, I guess, privacy practitioner, which I would imagine most of them do.
Exactly. Yes. So as you said, bigger firms will not even question it. It's part of their business project. They look at GDPR. Well, they look at data protection generally. But a small firm, we will see that a little bit later in our slides. Very often, the first stage of a small firm is marketing. How do they get known? How do they acquire new business? And that's where they actually may breach data protection laws, because they reach out to people who have not necessarily consented to be contacted. So yes, it is important for smaller firms. And if they don't have an in-house person, which is an extra cost, then you can always reach out to consultants, to law firms that will help you put what's the minimum in place, the minimum request.
So reach out to people like you, basically. If you don't
exactly.
have, okay, fantastic. So then we're going to go over some more of the potential nightmares, and then this is what I think gets confusing. Is how many GDPRs are there, and is it called the GDPR? And that's where well, wait. So what's that about? Is it one law or is it a few?
Yes, so there is one law in Europe, and it's the GDPR. What is it? It's the General Data Protection Regulation. It used to be a directive. I won't go into the details of regulations and directives, but directives in Europe are not directly applicable. So every country has to then enact a local legislation to apply the directive. And so that's where, when they made the directive effective, every country then had to apply it, and the diversity of legislation was still there, and it was very complicated. So that's why finally they came up with a regulation, which came into force in 2018. Okay. And so the GDPR is a regulation, and there is only one in Europe. It applies in all the countries. And then every country on very specific subjects can go a little bit further than the GDPR. So it's not totally unified, but it's much more unified. And the little difficulty is that Brexit made it a little bit more complicated. The UK left Europe, and they have their own UK GDPR now. So if you want, there is 2 GDPR. But at the moment, to my knowledge, the UK hasn't really changed the GDPR, but they're looking into it. The only thing is that it will remain quite similar, because they want to keep the recognition from Europe, so they can't diverge too much. And finally, in Europe, we have the small little country called Switzerland, and Switzerland has never been in Europe, so it doesn't apply the GDPR per se. And with 5 years, I would say not delay, but 5 years later, in 2023, last year, Switzerland enacted its own data protection law.
Okay. Oh, all right. And now we're going to talk, and at the end of this, we're going to be talking about my pet topic. And I think because when we're going through this, I realized how great of a foundation you were laying about how the law is, what it works. And so I said, well, wouldn't it be wonderful? For my audience who is impacted by the Foreign Account Tax Compliance Act, wouldn't it be wonderful to build up like what the GDPR, how it applies? And now let's take a specific example, how the U.S. government collects data on European citizens. And, that seems like it would violate that. So we're going to be talking about that a little bit more in detail, but let's get back and let's get into the details here. Who does GDPR apply to? Let's talk about this a little bit more now.
Absolutely. Yes, so the big question is, does GDPR only apply to European firms? And so the answer is no, unfortunately, for a lot of people. Of course, it applies to European firms, and just on a very small example, it doesn't apply to, it applies to European firms, but even if they have dealings only outside of Europe. So let's take the example of a French company that rents car abroad and doesn't have any activity in Europe. GDPR will apply to them because it's a French company.
Okay.
But if we come out of the European scope and we talk about companies abroad, let's take US companies, but it can apply.
How about, what if we let's take a US law firm that specializes in having European clients doing their tax work. Let's say a US tax firm that has a lot of European clients and creates content specifically aimed at various European retirement products, has things that exactly it markets itself as a firm that can do tax returns and clean up tax problems from Europeans. Would GDPR apply to such a firm like that?
Of course it would. It would absolutely. And it is one of the bullet points in that slide. It's offering services of either goods or, well, offering goods or services in Europe. But yes, absolutely. Targeting European people European people doesn't mean citizens. It's people in Europe. Targeting Americans in
Whoa.
Europe will
Whoa. Okay. So
drag you
just to,
into, yes,
well, I mean,
it's not a,
when I did learn a GDPR, I did have it my website applied to it. We did follow it, but I was a little offended. I was like, why do I have to do this? But I did it. I was like, okay, it's clear that it does apply. And a lot of our business does come from Europe. So I didn't want to take any risks. But yeah, so that I think that's a surprise for a lot of people. If you are, and I guess the rule is, and because, to me, this is a very intensive facts and circumstances test, because now let's just say that you don't target Europeans in any sort of way. You have a website, you don't. Most of your business in the US. Will you stop someone from Europe buying your product or service? No. But what about there where you have a US website, not really targeting people overseas, but someone from Europe does decide to go to your website and buy something? Will GDPR, will having one customer that's European trigger GDPR, now give you a problem? What about that?
Normally not. Normally
Okay.
not. If you have a website that is available and a European person buys from your website, that shouldn't drag you into
Okay.
GDPR. But if your website has any hint that you might be targeting Europeans, for example, using language that is used in Europe, French, yes, we speak French in Canada, but quite often if you advertise in French, it might be for France. If you advertise in Italian, it's definitely for Italy.
Yeah.
If you advertise in Spanish, it could be for South America, but it might be for Spain. If your currency is in euro, you definitely are under GDPR. And
Okay.
if you, for example, if you sell goods and you offer to send to European countries, you're also definitely under GDPR.
All right. So not necessarily everybody, but if you are, and I guess so it's a fact and circumstances, if you are trying to get business in Europe, then you would.
Exactly.
The use of,
Yeah.
the use of country flags might do it. I would say I've done that. There's lots of things. Yeah, no, there's no question about
Exactly.
yeah. So I have no question about
Yeah.
myself. And I think that's even something that did come up, that there's, I believe in a slide we have where a US tax return company was fined. I think that's coming up here. But before we get to that, let's talk about this landmark case of Google. What does it mean? What's this inextricable link? What's it all about? And this right to be forgotten. What's this about?
Exactly. So the landmark case is, the Google case is a landmark case because the decision of the Court of Justice gave the direction of where GDPR was bringing global organizations. So for people who thought, you know what, I'm in the US, I'm big enough, but I don't really do anything in Europe, I shouldn't be, captured by GDPR, that case showed you the contrary. So basically the Google case is the case of a person who wanted to claim his right to be forgotten. What is the right to be forgotten? It's a right for a person to say this information in that newspaper is old enough, is not important anymore, doesn't concern anyone, it's not of public interest, I would like it to be deleted. And if you gather enough reasons to have that information deleted, it's a right that you can claim. So the person first asked the newspaper where the information had been published in Spain, I believe, to remove the information. And then the person asked Google Spain and Google Inc., the search engine, to disconnect the connection, the link between the name and the result, the information. So it doesn't necessarily ask the search engine to remove the information, but the connection between searching the name of the person and the information popping up, you can ask that that connection be removed. And Google Inc., US firm, said that it didn't have to comply with that request because it was not under GDPR.
Oh boy. Oh
That's
wow.
where
So how did
the
that
Court
go?
of Justice, yes, that's where the Court of Justice of the European Union said that because of Google Spain, which does a lot of advertisement, which is profitable for Google Inc., that's where the inextricable link was shown. And the two entities were seen as one unit. And so that was the reason why Google Inc., the US company, was dragged under European law and had to comply with the right to be forgotten under
Okay,
GDPR.
I have a question for you. This is great. Okay, here's my question. Okay, because there is no GDPR in the US. Okay, so Google does whatever it wants. Now, let's suppose that okay, Google has something on me where when someone searches for a search term, something that I don't want people to see comes up on me. Okay, so now in the US, I don't even know how the mechanism. I'm basically asking Google to de-index. I think that would be the term. The search result. The search inquiry to query to my result. Now I can't do that. I don't know of any way to do that. But now let's suppose I move to say Switzerland. What if I move to Switzerland and I've been and now I'm there. I'm in Switzerland and I reach out to you, Sandra, to say, hey Sandra, could you help me out? Could you see about maybe getting this removed from Google? Do you think that could possibly? And by the way, do you help people? Do you help people with that aspect as well? Do you help people remove? Get negative results de-index or however that mechanism is. Is that something you actually help people with?
Yes, we can help people do that. The need to have the information disconnected from your name must be really important for you to make the move to another country, because we can't promise any results. And you need, the right to be forgotten in itself is quite complicated, and there are situations where you cannot ask for the information. A terrorist, that's not a very good example, especially nowadays.
It might be an uncomfortable example, but it's probably a good example, right?
No, but let's say a famous personality with rapes and very delicate situation might not be able to ask for the right to be forgotten because it has a public interest reason to keep the information. So you also need, you need to gather enough reasons for the right to be forgotten to be applied. And so we would need to look into your situation very closely before you decide to make a move. And we can't promise any results. I would say, I would suggest you move to Europe more than Switzerland, because I think Google has more presence in Europe and we could do the inextricable link.
I love it.
Confirmation a little bit more easily than with Switzerland, I would say.
Oh my! Well, and I'm just sort of thinking, we have so many clients who come to us to help them renounce their citizenship. They just can't, they can't do it. So, it really seems like an entire, there's perhaps an entire de-Americanization service program out there, out there. So, fascinating. All right, so that is actually a possibility. Fascinating, and it's great to know that you can help people whose privacy is being violated by, and it's really when the story doesn't have any, and basically it's when the story doesn't have any real news worth to it. It's just embarrassing stuff that you just don't want somebody to know.
Very old information, exactly as you said, embarrassing, that you don't really want to be connected to your name anymore. But let me just jump on that and say, we mentioned the right to be forgotten, but there's a lot of different rights. You have a right. You have a right for accuracy. So if the information is not accurate anymore, you have a right to ask that the information be corrected. You have a right to ask that people stop processing your information if they don't have to. And so there's a variety of rights under GDPR that were not necessarily recognized under the US. And that's one of the reasons. I don't know if you've listened about the debate, the streams 1, 2, 3. We're not at 3 yet, but it might be coming. So a citizen in Austria challenged a recognition that was given to the US by Europe back in 2010 or 12 by saying we are not safe in the US. And the Court of Justice actually ruled out, and the recognition was cancelled. That happened twice already. Now we have a data protection framework agreement that came into effect in September or October last year with Europe, and just came into effect. It's actually effective as the 15th of September this year with Switzerland. But we expect the next challenge by Mr. Schrim to see whether it's going to stay. And so one of the reasons of the challenge, there were two main reasons. One is the access by the US authorities to European citizen names or to European names. And second is the lack of recognition of those rights for people whose data are processed by companies.
All right. Well, all right, all right, fantastic. Well, all right, let's go on here because we wanted to talk about this. This is really, I think, this is who our clients tend to be.
Exactly.
So let's go over some of these, how it gets impacted. And here, yep, the first one you have here, exactly, right? A tax return company fined for sending millions of unsolicited text messages without consent. Oof.
Yes. So here we're really talking about millions, and if you are a small company and you send a few texts and a few emails, that's not really going to capture you. But if you are targeting a lot of people and you're sending millions of messages on a regular basis, then in that case, there were a lot of complaints that were gathered by the ICO, which is the UK regulator. And they open a case against the company looking at their activity. And so, yes, as I mentioned, as it's mentioned in the...
Okay, and I got a little follow-up for you then too, because...
Yes, sure.
Because a lot of people overseas will use one of these a lower cost company, one of the bulk providers, and I read recently that a lot of these bulk providers, I think Intuit, Turbo, I'm not sure which one was, I can't remember, I don't want to say who it was, but large companies were basically not. It wasn't that they were marketing the messages to get the lead. It's once the person was a client and typed in their sensitive tax information into their software, that company created a lead. Now, it didn't share all of its tax information, but it shared information on demographics, because you can find a lot from a tax return, right? Demographics, and now they sold those lists. And so I'm wondering, okay, because this happened on a large scale basis, and as I read it, but if someone was in the US, or I'm sorry, if someone was living in the EU, used one of these large companies, and this large company took that data and then sold it, which they did, what would be is there any chance of recovery? Is it worth their while to try to say, hey, look, you owe me damages, you violated the GDPR, and I mean, it seems like a clear violation of it. Is there any recourse for someone like that who used one of these programs and now their information is being sold?
Absolutely, because you're not supposed to sell information without getting the consent of the people you sell the information of. Basically, you're not supposed to make money off personal data of others.
That was the entire point. Yeah, no.
Yeah, exactly. Wow. So you should get the consent of people before you do that. Of course, firms do it because how are you going to find out? But when you find out, then
you find out, oh, they did
have a right to do something.
Now, is there a way to do a class action complaint to make it a little bit more cost effective? Because in this case, and I could send you some of the information on this, after we finish up, because in this case, it really is millions of people. And I would say, well, how many were in the EU? I would say probably about 500,000 people, 200, between 200 and 500,000 American, people in the EU, because it doesn't apply to, it's just not residents, as you said. It's if you are in the EU, so your citizenship status is irrelevant. So I'm wondering if, well, there might be would there be a mechanism by which to pool together all these people affected by it?
So class action is really a big thing in the US. It's
Yeah,
a little bit less usual in Europe,
okay.
but definitely what happens is that if there are many complaints to the regulator, then the regulator will definitely open an investigation and take into consideration all the complaints. Then probably everyone having complained will get a share of the compensation.
Oh, wow. All right. I might have to do some research for you. Okay. Because I see your point, right? So basically, if if there's enough people with the same claim, they'll basically make it a class action, essentially.
Exactly. Well, on the tax return company, that's kind of what happened, because the regulator received so many complaints that they put the information together saying, okay, it's not that just as, a random complaint. It's more than 2,000 complaints about this company sending text messages to people. So that's how they started investigating.
Okay. Well, you know what? Because you know what, and I'm thinking because I have a lot of my regular guests, John Richardson and Keith Redmond. We're really big in the U.S. expat community, and especially in Europe. So what I'm thinking of doing is just reaching out to see how many people were using, and I got to just get the right one. I believe it was an Intuit product. I really do, and maybe see that. And so just like here, just get enough complaints filed, and then the regulators will take a look at it to say, why do we have all these complaints filed? But I think it seems like it's a very untold story. What happened? And I can't, of course, hey, look, you're in America, you get no rights, but hey, it moved to Europe. Yeah, you might get some private. You might. So that's wonderful. So then we have this other one. Someone made millions of, by the way, I don't mind these people getting fined here. I mean, I'm usually against fines, but this is pretty obnoxious stuff they're doing just as it is, right?
It's exactly what I was saying at the beginning. Firms start with focusing on marketing. That's all, that's where they put all their money in. And they really don't want to hear about legal restrictions, legal and compliance. This is just making their business more complicated, and it's a cost that is unnecessary. And so what they do is they start marketing blindly without thinking about whether they can or not. And that's how they get caught. So we're talking about millions of unsolicited texts, unsolicited calls, reselling, you mentioned it, reselling personal information without consent, and so on. So all these fines are in that field.
Yeah, right on.
I have an example of a client who contacted me saying, I have a database of clients launching a new product. Can I contact everyone? And the first reaction was, no. How long have you had this information for? Are you even allowed to keep it for so long? Why do you have it? How did you get it? And then from a marketing perspective, you can only contact people who have already purchased from you a similar good or product. You can't just randomly send information to all your contact list.
Right. Well, here, you know what? I was just multitasking. I was just listening to you. They're actually here. I'll pull it up. I will pull it up. Let me share my screen here so I can show you what I'm talking about. And this is it. Pretty bad. Well, I guess there was. So tax prep companies shared private taxpayer data with Google and Meta for years, congressional probe fines. So this is an article from last year, and it looks like there were some fines for Facebook. Okay, but what about the companies that sold the data? That is, I'm just trying to find if they listing any of the firms that did do it. So I think, okay, so H&R Block looks like they were caught doing it. Tax Act and Tax Slayer. So really, if anyone, okay, they say, a TurboTax potentially, because they're just saying, well, we didn't use the tracking pixels to the same extent, but it looks like they used them. So there it is. I mean, if somebody, whoa. Yeah, I think we're
It's
going to
like
need to.
opening the Pandora box, because all of a sudden you unfold the situation. Well, you realize that a lot of different parties were involved, and that's how you reach out to one and another. So you can a case that opens can blow up to other people.
Yeah, no, I can see that really. Yeah, and I mean that might really be something there for someone if you did use that. So I will, that's going to be something I'm going to reach out to the expat community to see if there's people that use it, what they use and how they feel about it, because maybe there are a lot of people who would want to file a complaint. Now, so my question is, obviously, when you get a fine, who gets the money? When someone pays a fine, where does the money go?
That's the big question, because a lot of people
Yeah,
say, well, why would I open a case if it's just for the government to get the money?
yeah,
So if you open a complaint yourself, it's for compensation for yourself.
okay.
It's if the government, if the regulator, the data protection authority, finds out about a breach, they will open a case, and then the fine will go to the government. But if it's an individual who opens the case, then of course it is compensation for the individual.
So there you go. So you might want to, so it might be worth it to, I mean, it seems like this is a pretty big, what happened here, and it was revealed last year. So it might be something to get going on it sooner, so you at least get some of the fine as opposed to the government. Okay, so what else we have? We have another lifestyle, or what's the next one you have? You have lifestyle marketing, mother and baby limited
Yes.
file. Okay, so what was that? Reselling? Okay, so what was that kind of information they were selling? And
Reselling personal information. So basically, some companies just try to gather as much information as they can on people by profiling, by following people on applications and so on, and then resell the information. They're not allowed to. So reselling in personal information is absolutely forbidden unless you get the consent. So if you collect information openly by saying, hey, you are using my app, I am collecting information and I am selling it to other businesses, because they will be sending you information about promotion on goods that they're offering. And if you say yes, then of course it's allowed. But if it's done without your consent, then it's absolutely forbidden.
Oh, wow. Okay.
Basically, the GDPR, the main purpose of the GDPR was to give more power to individuals over their own data.
All right. Well, okay. And now this next example, I have a question. For the next one. Okay. Secure Home Systems fined 80,000 pounds for making unsolicited calls to numbers they had purchased from a third party, but did not have consent to contact directly. Okay. So now, was Secure Home Systems a U.S. company, or was it an EU company?
No, it was a UK company.
It was UK. Okay.
But basically, here they bought information, and they thought they could rely on what the third party had told them, saying yes, free. You get this information and then you can use it. But they had wrongly relied on what the third party. Well, they had relied on what the third party told them, which was not accurate. So the third party had not collected the consent properly. They were both.
All right. Well, now this leads me. So here's my question. Suppose I am a U.S. company, and I buy from someone a list from the U.S. Hey, yeah, and give me the phone numbers of people. I want you to give me the phone numbers of people, taxpayers who are making over, $400,000 a year. Give me a list of that. And they send me a list. I get the list. Like, yep, you have the right to contact all these people. Okay, and I look, it's like all U.S. numbers. Okay, I call one of the numbers. Person picks up. They're actually living in Switzerland. Would that person potentially have a claim under GDPR for being solicited? Because it's like their number is a U.S. number. They pick up the phone, but they've been using that U.S. number while they've been living in Switzerland or wherever in the EU. Could that apply there in that situation?
That's a tricky one.
Yeah, I love tricky questions.
Well, first of all, probably not Switzerland, because Switzerland is not in Europe. So yeah, right, GDPR, a country in Europe. But of course, you have to have a way to know that the person is in Europe.
Okay.
It's not a law that is tricky tricky in a way that you can hide behind a US number and then open a case because you're actually in Europe. The company who sells the information needs to know where the people are. Well, that's the accuracy question. When you have a list of information, it needs to be accurate. But if someone tells you that they're in the US and they have a US number, then they cannot then hide behind, I am actually in Europe.
So I think your answer is it's a depends. And I think, a few things you'd be looking for are, look, if it's a few calls, that's not what's going to get you into trouble. It's when you're doing millions and hundreds of thousands, right? That's what's going to get you in trouble. So a few calls here and there won't trigger a headache probably, but potentially there could be an issue. So you would just want to make sure a list that you're getting, there is nothing in. So basically what you want is the list that you're getting. There's nothing in there that would indicate that somebody is in the EU, and that you're not looking for anyone in the EU, and there's nothing in the list to indicate that they would be in the EU. Then even if you did contact them, you'd probably be okay.
Yes. Yeah.
Okay.
Yeah. If you apply the law strictly, even one call is too many. But you also have to be pragmatic. As we said at the very beginning, this is a legislation that has put a burden on a lot of companies. A lot of people will tell you, oh my God, GDPR, don't tell me about it. So, we have to be pragmatic. And if you have to make one call, it's okay. It also always depends on the size of your company. If you are a small business and you make 2,000 calls, that's already a lot. If you are a medium-sized business and you make 2 million calls, it's a lot. But if it also has to be a bit proportionate to your business. But
to your overall business. So the larger. So in a way, so it's like a ratio. So in a sense, it's a ratio of non-compliance. But if that's the way it is, that means larger firms have a clear advantage.
Because... No, not to that extent. A larger firm has to comply. I think a larger firm would have no excuse. They really have to comply from the beginning. But I'm talking about smaller businesses. The hairdresser will be a little bit less under the radar than a regulated bank.
Got it.
Okay. And so on. So you just have to take a pragmatic approach.
Got it. Okay. All right. So let's go through some of the reasons for these fines and, basically how to avoid them. Basically, you're giving us a blueprint on how to avoid GDPR fines.
Exactly. So I think here what we're trying to say is that you have some steps that you can follow in order to put all the chances on your side to avoid getting in trouble. And so one of them is having the right documentation in place. That's probably the first step. You have an internal directive, a regulation that explains how your company deals with data protection laws. You have a declaration on your website, your privacy policy, typically that you see at the bottom of your website, explaining to people how you collect information, for what reason, how you process them, how long you keep them for, and so on. And then you comply with that documentation, because simply having the documentation in place and not complying with it is also not a good advice. So you have to have all the right documentation in place. Then you have to comply with your data protection principles, which are listed here: lawfulness, purpose. So you have to deal with personal data in a lawful way. You have to have a reason, a purpose why you process information. It has to be proportional to your purpose. You can't have more information than you actually need. Proportional and necessary. In a lot of cases, especially in the medical world, you need to get consent before you actually do anything with data. It needs to be accurate. If the information is all dated, if it changes, it needs to be corrected. It needs to be kept with integrity, and especially security. A big part of data protection. So you have all the legal theory, but you have also the practical application, which is the security of the data. And so if you, for example, fail to minimize the data you collect, so you have more than you actually need, then this is one of the reasons why you could get a fine. Then collecting the data, you have to collect it with the consent of the people you get it from. That's why on website you inform people of the data you collect, and a lot of times you ask for consent. Data security is where you have to put in place everything you can under professional standards. So that's not, you think that's okay, so it should be fine. It's really compared to the common professional standards in order to keep the information secure. And if you have a breach, you can get into trouble again, and you may have fines. But not having a breach doesn't mean that you're not going to get a fine. If you are checked and there's an audit about your firm, and the regulator sees that your security is not up to date, you can also get a fine. And finally, a very important point is transfer to third parties or to countries outside of Europe. Or, well, yes, from a European perspective, definitely countries outside of Europe. So if you collect data but you keep it for yourself, the risk of fines is a little bit smaller. But who doesn't deal with the cloud today? Who doesn't deal with a third party? So anyone that receives the information you collect is a third party, and is a bigger risk for fines.
Oh, okay. So, all right. So when I hear that, I'm thinking about, when you're saying third parties who get your data, I'm thinking about a lot of, website plugins that are managed by other companies. And essentially they're seeing, that company is able to see your data. So as you did, even though they're not taking your data and doing anything with it other than looking at it, that right there could be the breach.
Absolutely. So here we're maybe getting into a little bit of a technicality, and we're going to use a little bit of legal jargon. But
Yep.
you are a controller when you collect the data, as opposed to a processor who only does what the controller asks them to do. Plugins, most of the time, are seen as controllers as well, because although they're just on your website, they're doing things for you, and they're also monitoring profiling people. They're going to use the data they collect for you to do more marketing and so on. So they're going to be seen as a controller as well, and they will have all the obligation of a controller. So here, the company will be the controller, and the plugin on their website will be a joint controller with the company.
Wow.
And they will have to agree who complies with what obligations and so on.
Oh, and then here's another one I was just thinking of too, because you're saying accurate data, how you got it. Well, I mean, because in this situation, let's suppose that you got a big list of customers, and it was some from a website, some that existed in 2008. Okay, a website existed in 2008 and collected a whole bunch of addresses and emails. I would say that would be a huge problem, to take that customer list, no matter what they tell you. Oh no, you can call them, it's fine. But the problem is, number one, that list was created before GDPR, right? That's a problem. Well, that doesn't comply with GDPR. How do you know that? Because it didn't exist at the time. So that would be a problem. And now two, this would be a close to 20-year-old website. And I'm just thinking, like, maybe the fact that it's so old would sort of infer an inaccuracy that really can't be allowed. I mean, would you something like, would you say, like, yeah, you wouldn't want to do that for those reasons? Does that make sense?
Yeah, so that's a very good question. There is no rule about how many years you can keep information for, and there is no rule about how often you need to get the consent from people. Okay. But the habit and what is expected from firms is that if you get information under consent, then you should renew the consent every couple of years. And you actually get that. I don't know if you have website that reach out to you saying, you are on my database, unless you confirm that you want to be kept informed about our products and so on, we will remove you from our database unless you consent to being kept on our database. Or sometimes they do it the other way around. They say, unless you tell me you don't want to be on our database anymore, we will keep you for another couple of years. But there is an expectation that you actually request the consent every couple of years. If you have a database from 2008 and GDPR came into effect after, first of all, there was a directive in the meantime. So, you should have complied with the directive also, which was before the GDPR. But in any case, if your database is older than GDPR, when GDPR came into force, you should have reconsidered your database, I would say. I have an example. I went to a doctor recently. I had never been to that doctor. And when I arrived, the secretary asked me if I still live that address and if I had moved or anything. And I was a bit surprised because I thought, I've never been to that doctor. But then I realized when I was very small, I had been to a doctor in the same center, but who probably had passed on all his patient health database to the new doctor who just took over the place, they didn't even continue the same practice. And so that's where I realized, so many people are actually not compliant. And they either do it because they're lazy to delete everything, because they think that it might be useful one day. Maybe they may do some mass mailing advertisement one day. Who knows? But people keep data they shouldn't be keeping.
Well, so I think one of the issues that I'm hearing when you say that, like, when you're buying a business from someone or you're merging a firm, you need to be aware of, okay, where did this data come from? And is it something that I should have? Is it something because essentially what's sold with the business is this entire data. But when you're buying that business, that also has to comply with GDPR.
Do you know what? You have a really good point here. I would say, and it's a question I already looked into a few months ago for a client who was envisaging selling his business. First of all, I think the first question, and we might see that in our future slide, the first question a business who will buy a new business will ask you is, not first, but one of the questions in the audit is, are you data protection compliant? GDPR, US data protection, wherever you are. And it's part of what you sell. If you are not data protection compliant, it's a hassle for the company who buys, because they will have to put, to make themselves compliant. So it's part of the price that you sell for. I think if you are GDPR compliant, you may sell for more than if you're not. So that's one thing. And the person who buys then should really question all these data and maybe inform the people they have data from. We bought this business. We have your data from the old business. We would like to know if you consent for that we continue keeping your data in our database and so on. You should have some sort of information. It's one of the main obligation under data protection. Under GDPR is information. You have to be transparent with the people you deal with.
All right. Well, wow. All right. Fantastic. Yeah, we're going to get into those slides you're talking about right now, because we have some great examples of what's going on here. Oh, before we do so, though, you explained this before, but just explain a little bit more since Brexit, what happened.
Yes. So you were asking me, are there many GDPR or not? There is, or there was one GDPR. It's the European Data Protection Law. But since Brexit, when the UK decided to leave Europe, the UK had to have their own GDPR because they became a third country. There are a country outside of Europe, like the US is outside of Europe. So the UK kept a lot of the legislation from Europe in all fields, including GDPR. They have their own local jurisdiction as well. But so at the moment, there is a copy-paste of the EU GDPR in the UK, which is the UK GDPR. There is a lot of discussions about diverging from the EU GDPR. The UK want to be a bit more flexible. Probably the UK will join what Switzerland has done, which is very similar to the EU to get the recognition, but a little bit different. And the UK will get there, but they haven't changed yet. So if you are a business outside of the UK, if you are a US business and you deal with Europe, you have to look into EU GDPR, you have to look into UK GDPR. And if you have dealings in Switzerland, you also have to look into the Swiss data protection law.
All right.
Some very active authorities in Europe are the French, the CNIL, the Irish regulator, which hosts a lot of the big companies like Google, Facebook, and so on.
Right.
You have Spain, which is very active as well, and Italy quite active as well.
Oh, all right. I think you're giving me a few ideas. I got to say, we'll get to it a little bit. So let's move on. So this is what I wanted to mention. This is where we go. I have had we've talked about FATCA and how the Foreign Accounts Tax Compliance Act. And Sandra, I just want to explain to you, how this works. The Foreign Tax Compliance Act. Basically, what it did is the U.S. government threatened sanctions on foreign financial institutions that would basically cut them off from any outbound U.S. wires coming in. So any payments due from the U.S. and the U.S. dollar being the reserve currency of the world, basically the government the U.S. government can withhold and stop those wires. And so really these foreign financial institutions kind of have a gun to their head to say, hey, look, you have to comply with this and send this information on suspected Americans to us in the U.S. so that we can do whatever we're going to do with it. And I'll explain what they're doing that in a second. But this is really what it is. And this is the mechanism of the Foreign Tax Compliance Act. This is what they're required to do. The foreign financial institutions are required to exercise due diligence to uncover any suspected American. And if they reach out, the person doesn't comply, they can still send that information on someone who is a suspected American. Now, how do you become a suspected American? Well, first of all, is that if you have a U.S. place of birth, if you have U.S. addresses associated with you, your bank may suspect you of being a U.S. person and send your information over. But now let's just suppose, and I think in this instance, let's just suppose that you are also a U.S. person, that you actually are an American living overseas. Regardless of whether you're an American or European, but you live in the EU, you 100% live in the EU, and now your bank is sending this data over to the U.S. Treasury. Now, what are they doing with it? Right now, they're not doing anything. The U.S. Treasury has all this FATCA data that they actually don't do anything with. And the reason why is because it comes over in a non-standard format. The Commissioner of Internal Revenue have commented on it. It's all the FATCA data that just sits there. It's collecting information just to create a database that could be hacked because the U.S. government doesn't even do anything with it. So, where I'm thinking is like, well, geez, we've talked about, I've spoken out of the issues of Americans overseas and everyone who's impacted by this breach of privacy, which is basically every EU citizen, because someone is going through that list. And it is possible that your information, even if you had nothing to do with America, goes to America, where they have your account values. They have all this information on you, things that maybe people would want, people would really want. They're trying to get you. They would also get your addresses too. They would know where you live. Maybe that's something you don't want, right? So, I went through your guidelines and your bullet points that you listed before. So here's the first one. You listed this before. Hey, look, if you fail to follow guidelines for the proper processing of data, for example, sending emails to users without their subscription or explicit permission. Well, look, no one has a choice. You're not given any choice whether or not your data can go there. And now what we know from the Commissioner of Revenue is that this data is not even usable. It just comes over and they can't even do anything with it. And there are no meaningful practices or guidelines on how private banking information can actually, if it's in a non-standard format, I'm going to say, look, that's just not secure. If it's not standard, you can't run security protocols on it. So that to me seems like FATCA violates. What do you think I got a point there? Maybe a potential point?
Absolutely. And that's the core of the problem with the shrimp cases that I was talking about. So it is very political.
Yeah.
And I don't think we can pronounce anything about the subject in the sense that, yes, there might be violation. And that's why people like this Mr. Shrimps opens cases and it goes up to the Court of Justice, and then it rules out the agreement that Europe puts in place with the US, because the risk is that the information goes from European people, whether US or not, people based in Europe, going all the way to the government in the US.
Right.
And so then when cases rule out agreements between Europe and the US, the dealings, the businesses between Europe and the US becomes so complicated that the countries need to find a new agreement. And that's been going on for almost a couple of decades now, where the two countries, well, Europe and the US, find agreements and then it's ruled out because it's, as you said, it breaches a lot of data protection laws.
Oh, good Lord, does it? Yeah. And then
but now we are in the third version of the agreement.
And again, here, and this is like, fails to get consent for the collection of personal data. There's no consent. There's no consent. There's none. No one even claims there's any consent. Failure to integrate measures to protect against data breaches. Okay, let me tell you something about the U.S. government. The U.S. government seems to create databases that exist simply to be hacked. And one that was hacked really badly was in 2015. The Office of Personnel Management was hacked, and it basically, hackers got information on every government employee ever. So addresses, and there were probably some CIA assets in there too. So a lot of spies, if you're doing business for the US, you can see how much, what the US thinks of you, because they won't even protect your data in a meaningful way. And by the way, no one was ever punished for this OPM hack that happened. Because, hey, look, bad things happen, right? Bad things happen. You can't predict everything that's going to happen. You want to take reasonable precautions, and that reasonable precaution can basically show, hey, look, I tried to exercise due diligence on this, but something happened. But in this case, when you don't punish anyone for a massive data hack, you're going to say, well, you don't have the policies in place to respect this data, because if something bad happens, you don't adjust anything. You won't hold anyone accountable. And now, which leads me to this one. This has just happened this month. If you read it in the news, I just checked it, and there's so much news going on, it's easy to miss this one. But and essentially it's this. I think everybody's social security number, if you have one, it's been hacked. 2.9 billion records have been hacked with phone numbers, email addresses, all basically from a government database. And now this is the thing. I checked my social security number, and everybody can check their social security number to see if they have been hacked, because I'm pretty sure it's everybody. And you can go there. I was hacked. My information's there. And so, here you are like, oh, we're going to send all this sensitive banking information to basically the most reckless people in the world, who will take no actions. Like, okay, well, this data breach happened a month ago. What is the government? Well, no, sorry, it happened a while ago, but we've been aware of it for a month. And what action has the government taken? And the answer is none. So we have, we really have a wildly irresponsible, I think the word would be controller in this case. Do I have that right? The United States in this case, because they're a controller. So they're the most reckless, irresponsible controller with the most data available. And when it's breached, oh, well, they just move on to collecting more data, right? I mean, that's where we're at. And let me see if we have what, and then, how can you find out who has the government shared the data with? Who else? What other government agencies? Are there third parties? The government uses a lot of third parties. Are the cloud servers, right? Who are they? What companies are those? So are those, and there's a lot of things going on. Who is running those sites? Are we going to say that's all 100% government, or do you think there might be some third-party vendors in there, right? So you have a huge problem there. You have more co-controllers, as you said, right? As you say. So as I look at it, that FATCA violates GDPR in every way, in every common sense. And so now, but now I think I have a potential solution that I wasn't aware of before, because what you're saying is that maybe what people should do is just file their own complaint. And essentially, it's any European whether you're an American person or not, but if you're in Europe, you have a bank account at a foreign financial, I'm sorry, it's not foreign to you, but at a financial institution that's subject to FATCA, I'm saying you should file. Can they just file a complaint on their own and say, hey, look, I want to file a complaint, or they could hire you to file the complaint for them. But if enough complaints come up, do you think something might happen?
And I think here the complaint would not be against the bank, but it would be against the recognition. Exactly. Yeah.
Right.
But that's why I think it's just a question of how many months or a couple of years before the next challenge to the agreement between the EU and the US is challenged. Yeah.
Well, because I'm aware of current, the challenge in the UK. A guest of ours is actually proceeding on, Jenny. She's the one proceeding on this. Jenny in the UK, she's proceeding on this. And then there was also the case in Denmark, Belgium. There was the GDPR, and for a moment there, GDPR stopped FATCA, but they kind of rolled through that. I think for political reasons. But my point is that if enough, because what hasn't happened is that we've just had a few cases go on and complaints. But if people just on their, just create a overwhelming complaints to say, hey, look, this is, FATCA is, the United States is violating GDPR. Here's my complaint. If we have 1,000, 10,000, 200,000 people file complaints, do you think something good could potentially happen from that?
It's possible, but it really depends. We would have to, everyone would have to file a complaint with their own regulator, and then complaints would have to be gathered and analyzed. But yes, there is definitely something that can be done.
Oh wow!
At a more
right,
higher level, I would say.
We really might. I think I'm going to look into that a little bit more, because we're always looking for ways to give people some help here. And I think a massive GDPR complaint, and then you're saying, the key countries are Ireland, Spain, France, and Italy. If you're especially in there, you really might get some traction going quickly. So, all right, well, I can't. What a wonderful podcast we had. I want to thank you. Wow.
Anthony, I think we might have forgotten one slide that
we did. Okay,
is quite important.
Okay. Yep. We'll get that up. Yep.
Have a couple of more minutes.
Yeah. Let's get that one up. Yeah. I didn't think we're missing the one on.
Just before this one.
Here we go. Yes, we forgot about
our potential nightmares. Our potential nightmares, and I think that's quite important, because it's if you're a small company, what can happen beside having a fine? From your business perspective, what can happen if you're not compliant? And so, business development. If you want to do clinical trials, for example, in the EU, and you're not GDPR compliant, it's going to postpone your trials. It's going to delay everything. Financial impact. If you want to, onboard a new client, whether it's a bank, it's a financial institution, a clinic, anything, if you're not EU compliant, GDPR compliant, you may be impacted, and it may slow down the onboarding. Due diligence for sale, or for like any entity that deals with European companies will have GDPR questions or data protection questions. How are you compliant with your local data protection laws? Business opportunities. If you are a small startup, but you deal with big players, with hospitals, with federal bodies, and so on, you will have data protection questions. And if you're not compliant, it's going to postpone again your dealings. If you're dealing with regulated entities, with regulated industries like the medical industry or financial services, you definitely have to be compliant. And when banks are audited, one of the big questions that is asked to them is also, are you data protection compliant as well? So some of your nightmares are slowing down your business, financial impact if you have a big client and you can't onboard them, and so on, losing opportunities because people finally go to a firm that is already compliant.
Right. Yeah. Right. That's huge. Yeah. Well, this has been absolutely wonderful, and I want to thank you for everything that you're doing on this. And I didn't know it was so. I mean, essentially, it's this: is that GDPR is out there, and it really can impact. It can really negatively affect your business. And I guess, and here's the thing: I was a little bit more suspicious of it, that it didn't really have much benefits. GDPR really doesn't have much benefit, but actually, it might be because people aren't using it in the way that could benefit them by filing, people aren't using it in a way that could potentially benefit them. And second, that if you do have, the way to protect you and your business is just to follow the right policies, is to have the policy in place and make sure you file it. The cost of not doing so is significant in fines. But I think really the opportunity costs of not being in compliance could be even the real big problem. The fact that you weren't able to bring on a big client or merge or make a big deal, that's actually the bigger problem they have. So people who are facing these issues really should reach out to you if it's something where they're not a large Fortune 500 company with their own in-house privacy practitioner. They could simply reach out to you and right here. And you don't mind if people email you? You're okay with
Absolutely, that's fine. And what I always say is, you have to take a pragmatic approach. We're not here to make your business more complicated and more heavy. Everything doesn't have to be done at once. Of course, you should have been compliant already since 2018 if you're dealing with European clients. So I will not tell you, don't worry about it and do it in a couple of years. But if you start doing it, it doesn't have to be done within 2-3 weeks. So you can do it at your pace. You can think about what's the most important to start with and do it step by step. And we're here to hold your hand and help you do it really with a pragmatic approach, which is the most important, I think.
Oh, that's fantastic. And I just want to remind people, if you are, I want to give a plug for Iris Medic. I am now a tax partner at the Bone Partners. We are, and so if you have an international tax issue, anything like that, you also can start and reach out to us here at irismedic.com/offshore. I just want to thank you once again, Sandra. This has been valuable. And I think that we might look for a FATCA solution or a GDPR potential solution to FATCA. That does excite me and all the opportunities here as well. So I want to thank everyone for watching us today. And I would say be sure to subscribe and turn on the notifications. That way you know when we're going live. Sandra and I and everyone, we're all really busy attorneys, so we don't necessarily get the time to have a set time. So we go live when we can. So we always like people when they can participate. So turn on those notifications, then you know we will. I want to thank Sandra so much. And I also want to thank Olivier too, because he brought us together. So
absolutely.
I want to thank
Merci, Olivier. Merci, Olivier. And Anthony, thank you very much for the invitation. It was absolutely great. And if it's of interest to people, and we hear that some people want to know more about specific subjects, we can deal into, because it's a huge topic, as you see.
Yes, it is. I know. I see. Yeah. We've only scratched it, right? We've only scratched the surface here.
But we can choose and pick subjects that are of interest to people and dig into them a bit more.
All right, I'm thinking of some ideas for next one. So thanks so much, and thanks so much, Sandra. Good.
Thank you very much.
This is Anthony Perrin for Iris Medic. Thanks for watching.
Thank you. Bye.